Okay, so we're going to finish up talking about Chapter 3 today, and there's just a couple of things that I want to look at as far as these defenses go. We're going to look at justifications, we're going to look at excuses, and I'm not really going to hit much on procedural defenses, but I will mention them briefly. Justifications. Basically, a justification as a criminal defense is this. A person commits an act, they admit to it, but there was a good reason for it. They actually admit to committing the act, but there was a cause for it. There are one or two things that I want to get into with this one, and the first one is the idea of self-defense. Self-defense is allowable under law. However, there are certain circumstances and certain criteria that must be met. First of all, if you're claiming self-defense, you cannot start the argument or start the fight. If I come up and I start a fight with an individual on the street, I start a fist fight with them, they start hitting me back, I can't take a knife and stab them and claim self-defense because I started it. I am the one who is responsible for stepping back and ending it, and I cannot claim self-defense typically in those matters. The other thing about self-defense is we get into what's called the castle doctrine. North Carolina actually does have this now. So if I'm at home at night, my wife is there, my two girls are there, someone breaks into my home, I have the right to defend my home. I have the right to defend my family, up and into including deadly force. North Carolina now says that, especially in the home, if a person is breaking in, we can logically and legally assume that this individual is going to do bodily harm to someone in there, and so we have the right to stop that threat as possible. It also extends this right to a person's vehicle and workplace, but those are limited circumstances, and you would need to consult with an attorney or someone before using this type of force. The other thing we look at with this is what we call defense of others. There are certain circumstances when the law allows me to defend a third party. For example, I have the right to step in and defend my daughters. If somebody is attacking them, because I have a legal responsibility over them, I can step in and defend them. My wife, the same thing as well. If I see somebody getting injured on the street, I can step in and try to stop the attack. However, we get into some difficulty here as well. If the person I am assisting actually started the attack and I assist them, then I can be held in some cases legally liable as well. So just because somebody's getting attacked, we have to be careful here, and we come to their defense. We have to be careful in whether or not they actually precipitated these offenses or not. One thing I do want to bring about self-defense, in no circumstance are we allowed to use self-defense, especially homicide, or where we're killing somebody, in defense of theft of property. If somebody were to come into my office here and take a stapler or take a piece of property, I could not use deadly force to defend property. So under no circumstances can you have that happen. The second one that I want to mention is what we call excuses. And I'm looking in your book, and it talks about an excuse does not claim that the conduct in question is justified by the situation or that it's moral. It claims rather that the actor who engaged in the unlawful behavior was at the time not legally responsible for their actions. The one we basically think about this is what we call the insanity defenses. Now, I just want you to keep something in mind. First of all, insanity defenses are not that well used. In other words, there's not a lot of them out there like you see on court television shows. Matter of fact, less than 1% of all cases actually result in some type of insanity plea or in some type of insanity type of case here. The one that North Carolina uses, and I'm just going to talk about this one briefly, and your book mentions this, is actually what we call the McNaughton rule. And there's actually a very nice color picture in your book that shows which rule the states use. We use the McNaughton rule. And the McNaughton rule really comes down to this, that a person has to have a diagnosed mental defect or disability, and that defect or disability causes them to not understand right from wrong. So it's not like they can just get up on the stand and say, hey, I have a disease or defect, consider me innocent or not guilty. No, they actually have to show they have a disease or defect, but that disease or defect actually causes them not to comprehend the wrongfulness of their actions. So that's essentially what the McNaughton rule comes down to. The other thing that I want to mention real quickly is what we call procedural defenses. And these are listed in your text. Again, I'm not going to go over them a whole lot. Procedural defenses you can typically think of is that the defendant was somehow or another discriminated against in the process of the criminal justice system. This can be where the police go through and unlawfully entrap the individual. This can be where they're denied a speedy trial. It can be where the police commit fraud, where the police illegally arrest somebody as far as using planted evidence and things such as that. Those are procedural defenses. And like I said, these are ones where there is a flaw in the process of actually charging somebody and convicting them. That's all we've got for Chapter 3. If you have any questions, please post them up in the Q&A forum or email me, and we will continue on with Chapter 4 next week.